Okay, so we are now recording. It is on, and we're at about 26 people, and people are still slowly starting to jump on board. Richard did one. Kim Buckingham did a probate transaction. How many of, show of hands, who is a certified probate specialist? Did anybody get that designation? I know Lucy got one. Magda, awesome, very cool. So I'm studying for my broker's exam right now, and I'm having to memorize all these funky terms and verbiage, you know, codicil and executrix and all this stuff. So, you know, it's very confusing. It can be very confusing, but I'm glad that Andrea is going to be able to clarify on how the process works. So it looks like we still are at about 26. Rod's joining in now, 27. All right, so we're slowly starting to gain some traction here, but it's one after one. So we're going to kick things off, you guys, and welcome everybody. So as I mentioned before, Andrea Shoup from Shoup Legal is here on the call with us today. Andrea, tell us, I know that you are one of very, very few attorneys in the area, and correct me if I'm wrong, that are certified as a probate attorney. Is that correct?
Right. So the California State Bar has a certification, and only one attorney, me, in Marietta has that designation. It's a certified specialist in estate planning, trust, and probate law, and I'm one of 3 in Temecula. So there's there's only 3 of us in the Temecula, Marietta area. I'm the only one in Marietta who has that designation.
Well, I'm really excited because I know that you put on a much better presentation than David Shoup. So this is really exciting for us. It looks like people are still starting to slowly jump in. So, but it is being recorded, Andrea. So welcome to the presentation. Thanks for taking the time, and go right ahead.
All right, very good. Well, thank you. I appreciate you allowing me to be here. So I'm just going to start sharing my screen, and we just tested it out, and now it looks like I'm no longer a co-host. So Felipe, can you make me a co-host again? I don't know what happened. Okay, perfect. I appreciate it.
Done.
And I am going to share my screen with you, and we will get started. All right, let's see. Stop share. So are you, a question, are you seeing just the presentation, or do you see everything else along with it, notes and everything?
I do see the notes. I see the presentation and the notes as well.
All right, so that did not work the way I wanted it to. Here it is. All right, how about now?
Perfect.
Awesome, very good. All right, so I hope everybody can hear me. If you can hear me, if you could just let me know in the chat that you can hear me. If you could just give me a Y or a yes or something of that nature so that I know, yes, you can hear me. Yep, okay, perfect. All right, great, I appreciate that. So again, I'm Andrea Shoup. I'm an attorney here with Shoup Legal. We have a team that helps us out, and today we're going to be talking about the ins and outs of probate real estate. So I have here helping me out is Marianne Shoup and Carl Kujer with Lawyer's Title. They're going to be helping me with some of these things from a title perspective. So what we're going to be learning here today, we're going to be talking about what to do when a property owner dies. We're going to talk about the probate process, and we're going to talk about how to list real property in probate, and also how to avoid probate. As we know, this is very important information. I mean, really, as an agent, you need to understand, you need to know what to do when a property owner passes away. So with this information, you're going to be able to better serve your clients and help them either through that process if they have to sell a property after someone's passed away, and then also how to avoid it. So it's interesting when I talk about the probate process, probate, a lot of people don't really understand what probate is, but they know they want to avoid it. So we're going to talk about that as well. So what to do when a property owner passes. So just by a quick show of hands, how many people have had that happen? They're listing a property, and we find out the property owner has passed away either in the middle of the transaction or beforehand. You go to close and you do that. So if you could just type in the chat for me, just me, you know, we'll just do a me. Yes, that's happened to you. Yep, okay. I see some people have had that experience. So it's a very interesting experience when all of a sudden, oops, the property owner has passed away. So what do we do? Well, if we have the property held in a trust, it actually becomes very simple. So when the property was held in the name of a trust, and the person who was the trustee or on the deed in relation to that trust has passed away, it becomes actually fairly straightforward. We need to file, complete, and record an affidavit change of trustee. Then that change of trustee, whoever that successor trustee is, now has the ability to list and sell the property, and we continue on. It is no problem at all when the property was held in a trust if that property owner passed away. I will say, if there was no successor trustee listed, or if that successor trustee themselves has passed away or they're unavailable, unfortunately, we may need to petition the court for a probate court order. But generally, if the property was held in a trust and that property owner passed away, then we are able to continue on with that transaction pretty easily. Now, what happens if the property was held in joint tenancy and now the property, one of the joint tenants passed away? What do? Well, we file an affidavit death of joint tenant, and then we continue on. The remaining joint tenant, that person, they become the sole owner, because joint tenancy has essentially a built-in successor qualities to it. So when there is a joint tenant listed and that one of the joint tenants passes away, it goes to the surviving joint tenant. All right, so what happens if the property was held as tenants in common? All right, we know what tenants of common means, right? That it is a default. One, it's a default when nothing else is listed on a deed. But also, some people take title as tenants in common. With tenants in common, there is no automatic succession. So we talked about the joint tenancy. It had an automatic succession. Tenants in common, it does not. So it results in it being held just like if the property is held in that person's individual name. I'll talk about what that means in just a second. But when we have a tenancy in common, so there's two people on the deed or more, and there's a tenancy in common, then if one of those tenants, one of those property owners pass, then it's held as if it was in their individual name, because there is no automatic succession. All right, and in that case, unfortunately, we do need a probate court order. All right, so what happens if the property was held in somebody's individual name? We just talked about that. So what happens when that individual property owner dies? Well, we have no one to sign the deed, right? If the property is held in someone's individual name, we have nobody to sell or to sign the deed to transfer it. So I'm going to ask Carl and Marianne if you could, if you can unmute yourself so you can help me out. So if the person whose name is on the deed passes away, what are you looking for so we can close that transaction, so we can sell that property?
Well, if it wasn't held in a, can you hear me?
Yes, we can.
If their interest was held in a trust, if they held it as an individual, a single man, an unmarried man, or single woman, unmarried woman, it would need to be probated if there was no trust established.
Now, what happens, let's just say, and I hear this all the time, Andrea, don't worry, I have power of attorney over my dad. He passed away, but don't worry, I have power of attorney. How far does that get us?
The power of attorney dies with the person, unfortunately.
Yep. So unfortunately, even if somebody had a power of attorney, it does not help them out after the person passes away. It's a very common misconception, common misunderstanding that I see. Unfortunately, that just doesn't help out. And Marianne and Carl, they provided us with this great chart to explain. And maybe, you know, if anybody is interested in having a copy of this chart, it's a very handy tool. If you could just put your information in the chat, just put your email address with the word chart in it, so we know what you're looking for. We can send that out to you. But Carl, if you can help us out and tell us what this chart is saying and doing.
Well, basically, it is establishing the different ways in which people can take title, and then telling you the ramifications of what it means if the the distribution of the interest. For example, community property. Well, there's two different types of community property. There's one with standard, and then there's ones with the rights of survivorship. Compared to joint tenancy, the effect is pretty much the same when someone dies. I will say consult your tax attorney, because allegedly the community property with rights of survivorship happens to have a few more tax advantages than, say, joint tenancy does. But this matrix, if you will, basically describes all the vesting options available to people when they take title to real or interest in real property. And among other things, and for this purpose, is telling you the disposition upon death and what happens. And if you can take a quick look across there where it says death, really the only thing that helps when both parties or all parties are no longer with us on this earth is a trust. And that's where Andrea comes in very handy.
Well, and how title is held to a property is so important. So I will say, pull title early, pull title often. Make sure you have a great relationship with your title rep so they can help you out, so you know what you're dealing with before you get too deep in it. So we talked about if it's not in a trust, unfortunately we end up in probate. End up in probate court. So what is probate? I'm often asked that. What exactly is it? I know it's something I want to avoid, but what is it? So it is a court process to transfer assets from one person to another after that person's passed away. It's a lengthy process. It takes, I'd say, on average, about 2 years or so to complete, unfortunately. That's even in Riverside County, where our courts are fairly efficient, believe it or not. Riverside County is one of the best courts to be in probate, but in other counties it takes 2-3 years to get a probate completed. It's a very public process, so anything and everything we think of as fairly private information, our bank accounts, our bank account numbers, our bank account balances, it's all public record. So all of the personal details of our financial life, it becomes very public. It's also a very costly process. I'll talk about the cost of probate just a little bit later, but it's expensive. Anytime I say we have to go to court, just think it's gonna take a long time and it's gonna cost a lot of money, unfortunately. So when does probate occur? Well, probate happens when there is any real property, okay? Any real property. It doesn't matter if it's a multi-million-dollar lavish estate or it's a $5,000 lot in the Salton Sea. We need a probate court order if that property owner died for any real property, okay? And it's also when assets are over $166,250. That amount is adjusted every year for inflation. So that's when a probate court order would be needed, when probate would occur. So why do I keep making this distinction? Probate court order and probate. What's really the difference? Well, probate court, it's a court that handles a lot of different types of things. It's like traffic court. Were you speeding? Was it a parking ticket? What is it? You know, it's kind of all encompassing. That's probate court. But there's a whole probate process. I'm going to talk about that process in just a minute. Or there's a probate order. If I need just an order, a lot of times I can get into court, get my order, and come back out, and it's not nearly as long as that entire probate process. Okay, so that's the difference. Go to court, get me an order, come back out, or an entire probate process. So when is a probate order needed versus that process? Many times if we have a surviving spouse, we can do a spousal property petition. It's only available for spouses. That means they are married or domestic partners, registered domestic partners with the California state, the whole registry process. That doesn't mean they've been living together for years. Okay, there is no common law marriage in California. There has to have actually been a wedding date, a marriage license, a domestic partnership license, everything, okay? So that's available. It's a spousal property petition. We're able to go into court, collect the person who passed away's property, and then give it to the surviving spouse with just needing that probate court order. We're also able to do that if the, Affidavit regarding real property of small value. So if that real property is valued under $66,000, then we can get a probate court order. We don't have to go through that entire process. All right, so that's where those different values come into play. We're still going to probate court, but we get in, get our order, and come out versus that entire process. That's also available for a petition to determine succession to real property. That comes into play at $166,000. And those amounts are adjusted every year for inflation now. They just started doing that in this January. It used to be just $50,000 and $150,000, and it hadn't changed for years. But now they're finally getting with the times, changing it. So if the property value is under $166,000, we're able to get into court, get our probate court order, and come back out fairly quickly. All right, that's also available if we need a Hegsed petition. All right, who has dealt with a Hegsed petition? Give me, yes, me in the chat if you know what a Hegsed petition is. Anybody know what this is? All right, a Hegsed, I see Carl's hands up. Carl, of course you know, you've got to know. So a Hegsed petition, it's something that's available when we have a trust, okay, but the house wasn't in the name of the trust. Unfortunately, I see that happen all too often. It usually happens if, one, somebody you talked with or used an attorney who didn't fulfill the process and they didn't get the house transferred into the trust. I actually had that situation. It made me so mad when the son came in to see me. He said, Andrea, my dad passed away. Don't worry, it's in a trust. It should be simple. We pulled the title. Thanks. Of course, we also pull title early and often. We pull title. We're like, ooh, I'm sorry, the house is not in the name of the trust. It's still in your dad's name. And we opened up the book. There was a Post-it note on the trust that said, don't forget to transfer your house, written by the attorney. Oh, it made me so mad because it just didn't get done for them. Unfortunately, we had to go to probate court and we were able to get this file this Hegsed petition. And it essentially lets us get into court and say, hey, judge, they really meant to have that house in the trust. Come on, pretty please give us this court order and don't let it make us go through that entire probate process. Okay, so it's something that is available when there's a trust there and the house did not get into the name of the trust. I also see it occur when there's a refinance on a property. Sometimes the lender won't refinance in the name of the trust and they'll take it out of the trust, but it doesn't get put back in. So just keep that in mind. Either if you have a trust or you're helping out your clients, just remind them if they ever decide to refinance, make sure that they pull title early and often and make sure that it gets back into the name of the trust. All right, this is, we might also need a probate court order when we need, if there was a trust, but there was no successor trustee listed or something happened to that successor trustee. We might need to go to probate court for an order. But that's when we can get in, get our order, and come back out whenever and not do that full probate process. But when a full probate is needed, unfortunately, it's needed and there is no avoiding it. So Carl, from a title perspective, let's say, we do not need that full probate, but I have a will. I have a will in my hand and it says, give my house to my son. Can you accept that?
Sorry. Yeah.
What about a handwritten note? Mom said, you know what? This house goes to my daughter. Pretty please. Come on, Carl. It says it right here. It's in her writing. Can you accept that from us?
That goes about the way of the power of attorney that the person had also. Yeah. It's going to have to go through probate. There's no question.
And it's unfortunate, but it's the process that we really need to have happen, because if we don't have something, we can't go off of a handwritten note. Who's to say that this will was valid or not valid? We need that probate court order. And when we need that full probate, There is no avoiding it. So let's talk about that. Let's talk about that full probate process. So probate overview. The probate process basically starts off with filing an initial petition. Okay, that is something that the attorney does. They complete a probate petition, file it with the court. And usually we get an initial hearing in about 45 to 60 days. Usually that's when there's not a pandemic happening. Right now, unfortunately, that's more like about 3 months.
Wow.
Our hearing dates right now, so right now we're at the almost end of July. I'm not getting court dates until end of, into October now. It's awful. So this whole process is getting extended just a little bit more, excuse me.
And Andrea, we have a quick question too. I don't know if you
Please.
want to address that first or you want to continue on. So we have a question on the chat. I'll read it off real quick if I can pull it back up. So Magda's asking, if there is a will, do they ever give court orders instead of going through the entire process of probate, the full process?
Yeah, so wills go through probate. So having a will or not having a will does not affect whether we go through probate or not. Let's say there is a will and the property was, $50,000 under that $66,000 limit. Yes, I get that probate court order. Or if the property is valued at $166,000 or below, yes, I get that probate court order. Whether there was a will or no will, that's the determining factor, not the fact that there is a will. If the property is over that $166,000, unfortunately, we got to go through probate. The only other way not to is if there was a surviving spouse who was going to get 100% of it. Sometimes, unfortunately, the surviving spouse doesn't get 100% of it. But if they were going to get 100% of it, we can use that spousal property petition. That would allow us to get just that probate court order, but it's not the existence or non-existence of a will. It's the value of the property that makes a difference. Does that answer your question, Magda? Okay.
Yes, and also regarding the 166,000 in assets, just to be clear, it's not the sales price of the home, it's the actual equity. Is that correct?
No. It's the value of the home. It's not equity. It's actually the opposite. So it's the gross estate value. So let's say we have a $300,000 home and there's a $250,000 mortgage. The equity is only $50,000. It's still going through probate because they look at the value of the home, the full $300,000.
Well, that's good to know for sure. And then another question, are bank account numbers public?
Yeah, unfortunately. When I file my petitions, I just use the last 4 digits to keep a little bit, but no, it's required because there's several different reasons why, but we have to know, one, that we collected all of the decedent's assets, and also that this is the account that belongs to the decedent. In fact, we even have to file bank statements with the court showing it. So it's just, that's what the courts require of us.
And then one more question. What if the surviving spouse is not on the title?
Yeah, so that's a great question. So it comes down to, there's 2 different things that affect it. Let's say it's property purchased before marriage, so that's someone's separate property, or maybe they got it as an inheritance during marriage, that's separate property as well. So how that's treated is much different than community property. But the process is still the same. We are able to go and get that spousal property petition. There's certain times where we may want to do something different. And I'm not going to get into all the details of that. I could go on all these different little, trails. But if the spouse was not on title, they have to go to court and they need a court order of some sort, usually through a spousal property petition. If it's community property, then it goes to the surviving spouse. That's what the intestacy laws tell us. If it was separate property, they may only get 1/2 or 1/3 of that property. That's all the surviving spouse is entitled to. So
cool.
It also comes into play and becomes a challenge sometimes with different lending. Let's say husband has bad credit and wife is getting the loan, or vice versa, whatever the case may be. We'll just go with that. Husband bad credit, wife is getting the loan only in her name. What happens to the lending process? Usually they make the husband sign a quitclaim deed or interspousal property deed saying that's all yours as your separate property. Oh, that breaks my heart when I see it, because now if wife was to pass, husband only gets 1/2 of his home. It's awful. And if wife had children, he might only get 1/3 of his own home. So it has some really, really dramatic and drastic effects if it's, that's why how you hold title is so important. And there's so many of these nuances that many times people really don't understand. I mean, this isn't stuff that is just common knowledge. And so if you don't understand it and you're not talking to someone who does understand and know, it has some really devastating effects. I have that actually going on right now. Surviving spouse wasn't on the property, wasn't on the deed, and they owned the home for 30 years. He bought it right before they got married, kind of like as a wedding gift. And because of that, she now co-owns the house with her mother-in-law. And unfortunately, mother-in-law didn't really like her. So it's an interesting effect. So how you hold title is so important. Okay.
Hey, can I interject one thing real quick?
Yeah, please.
It's something that it's funny. We talked about the last time we held a session like this, but we just saw it again recently, where two people who weren't married were on title as joint tenants, but one of the joint tenants deeded their interest to another party and gave them a partial interest. And then one thing that people don't realize is that if you are joint tenants and one of those people deed their interest, that breaks the joint tenancy.
Right.
And automatically creates tenancy in common. But our situation got very peculiar because now they were going to go sell that property and that person died as a tenant in common. So now the other two parties are still alive wanting to sell the property, but the person who died, who was now a tenant in common, their interest has to be probated. So their whole thing is waiting probate. It's a mess.
Yeah, that's crazy.
It is a mess. It is a mess. I would say, I'm going to talk about DIY planning later on, but DIY anything, oh my goodness, it has some very unintended results as we've heard. So back to the probate process. So we have the initial petition. At our initial hearing, that's when the court will either approve or disapprove that hearing or the petition. And ideally, we get after about 15 days or so, letters granted. Unfortunately, right now with the slowdowns in the court, usually I could get my letters granted. I'm going to talk to you about the importance of letters and the significance of it, but in just a minute. But it used to take me about a week or two to get those from the court. Now it's taking about a month to get those. So letters, I'll talk about it more later, but that's the authorization. That's what gives somebody authority to act on behalf of the estate. So after letters are granted, then we have the inventory and appraisal phase. This is where all the assets get inventoried. That's where you're saying, well, why do the bank accounts need to be on there? Because we have to file this inventory and appraisal and tell the court, these are the assets of the person who passed away. And this is their account at Wells Fargo, Bank of America, wherever they are. And this is the balance that was there at the day of their passing. So we must file that within 4 months of letters being granted. Then about a year or two later, we're able to file our accounting and the petition for final distribution. And then we get a hearing after that. It used to be I get my hearing in 45 to 60 days. Now, again, unfortunately, it's about 3 months out. But after that hearing, that's when we finally have our order to distribute all the assets. So the part that you are going to be most concerned about is when can you list the property through this process? You can list the property when the letters are granted. Again, letters, that's authority. That's authority for someone to be able to act on behalf of the estate. That's the person who can sell the property, whoever has those letters. Usually I could get it within 60 to 75 days after I file my initial petition, but now that's again about that 3, probably even 4 months now. Thankfully the courts are open, but they're backlogged from being closed. And so it just gets hard to get into court, unfortunately. So that's a summary of that probate process from initially filing the petition, when you can sell the property, and then when everything gets ultimately distributed. So even though the probate process takes about, I'd say about 2 years or so, you aren't waiting till the end to be able to sell that property. And I will tell you, please, please, pretty please, even though you want to, Do not list the property before you have letters. I have seen that go wrong so many times. And the last thing anybody wants is that stale listing. You don't want to be that troublesome property that the buyers, they don't want to deal with it, right? It's hard enough to sell a property in probate. Nobody wants to add to it. I had a situation where we needed to evict some people, and at first they were like, "Oh yeah, we're gonna help out. We're gonna be cooperative." Of course, you know, I told the agent, "Please don't list it. Don't list it. Just don't do it." It was initially listed for like, I think, $750. They had offers in the 800s. It looked wonderful, but the tenant wouldn't get out, and we had to evict them. And so that took 4 or 5 months. And by the time we ultimately sold it, I think they sold it in the low sevens, because it had become that sale listing, and there were so many problems with the tenants. The local agents just knew, oh my gosh, you don't want to deal with them. Who knows if it's ever going to get out? So please, please, please don't list it until you have letters, then list it. Okay. It will save that your listing and make sure it's not a stale listing. Okay, so some common probate terms. So first one is executor, personal representative, administrator, as Felipe said, executrix. Okay, that is a female version. They're, you know, old terms. We really don't use them anymore. Really, it's a personal representative. There is a difference between all three of those words that I have on there, or terms. For your intents and purposes, they're all the same, okay? This is the person with authority. This is the person you want to talk to. Whoever is that personal representative, the person appointed by the court, whoever that is. If you're talking to son and he's like, but it's my mom, of course I have the ability to sell her house. No, he doesn't, until he's actually appointed by the court as the personal representative. Again, sometimes it's called the executor, sometimes the administrator, but it's the personal representative of that estate. Okay. Probate referee. This is a court-appointed appraiser. So remember those values I was talking about, the $66,000, $166,000? I'm often asked, well, who determines the value? Well, it's not me, it's not you, it's a probate referee. Okay, it's a court-appointed appraiser that we've got to use. We have no choice, no option, gotta use a court-appointed probate referee for the appraisal. They're the ones who determine the value. They're the ones who tells us what that value is, okay? What's an heir? So an heir is somebody who would normally benefit from someone else. For example, I have 4 kids. My heirs would be my 4 children. But let's just say, and the difference between heir and beneficiary, let's say while I love my children, I really don't want to leave them anything. I love the spotted owls, and I want to save the spotted owls. So I give everything I have to the spotted owls. Well, the spotted owls would then become my beneficiary. Okay, so that's the difference. Heirs, that's who would naturally inherit legally, who you decide will inherit if you do set up your will or your trust or whatever. That's your beneficiary. Okay, that's your choice. Next, go ahead, please, Felipe.
Can you assign your pet as a beneficiary?
You can, we do pet trust. It's interesting. So there's
crazy.
Yeah, you would be surprised. I think it's Leona Helmsley who left her dog like $12 million. And the judge actually said, you know, we're going to reduce that to $2 million. That will definitely keep. I think the dog's name was Trouble, of all things, right? I think it'll keep Trouble in the living up to the standard to which he has become accustomed.
Right.
So yeah, it's very interesting. But we actually do that a lot for horses. So if somebody has large animals, we do that a lot for horses, and we do it for dogs and cats, and,
wow.
and I've done one for a parrot as well. So we do them. Let's see. Okay, letters testamentary, letters of administration. Remember I was talking about letters before, and that's the authority. Well, there's letters testamentary and there's letters of administration. Don't worry about the difference. Yes, there's differences, but for your intents and purposes, there is no difference. Those are basically letters. It's letters of authority. So that is what the court actually gives to the executor or personal representative to allow them to act on their behalf. Let's see. Let's see. Okay. And then, so here are the terms. We're going to talk a little bit about the probate listing agreement. There it is. So how do we complete that listing agreement? Where do you get your information? So here's a copy of letters. Again, this is from the court. This is what the court and the judge actually signed to give authority. So you're going to want to know, you know, right there, it's going to say letters, and it'll say whether it's letters testamentary, letters of administration. We'll also be able to get the case name. So who, and that's the whoever passed away, right? Is it Mary Smith? Is it Mary Jane Smith? I will tell you. So remember, if you're pulling title early, you're pulling title often, you're going to find out what how the title's actually held. If the title says Mary J. Smith and you don't see Mary J. Smith on these letters, tell somebody, tell the attorney, say, hey, you know what? I noticed it says Mary J. Smith on the deed, but these letters don't say Mary J. Smith. Is that going to be an issue? Spoiler alert, yes, because title's going to need to see it exactly how it is. So just make sure you're aware. And you might think, well, it says Mary Jane Smith. Of course, that's the same, right? Unfortunately, it is not. It has to be exact. But this is where you get that information from. Let's see. Where do we find the case name, or I'm sorry, case number? It's right up there, and it'll say case number on there. So you pull it right off of the letters. We'll also be able to get who has the authority, right? We want to know who has the power, who's that administrator, personal representative, executor. Well, it's going to say right there because the court's going to say who they're appointing. They're going to appoint Sally Miller. That's who has authority. So that's where you find out where you know who has authority, who's going to be signing your listing agreement, and who's going to be able to ultimately sign the deed with the house when it gets sold. All right, and we'll also be able to see what kind of authority is the administrator has. Do they have full authority or do they have limited authority? That makes a difference. So tell me, who has had to sell property and with limited authority or need court confirmation? If you could put just CC in the chat, just let me know if you've had to go through the court confirmation process. We asked earlier who had gone through the probate process, but I wanted to know who went through the court confirmation process. Okay, Camus and Associates, they have. If you've gone through it, it's an interesting process. I'm going to talk a little bit about it in just a minute, but it's very different than a normal listing. It can get a little bit lively, but that's just kind of the legal geek in me because I kind of like this stuff. Okay, so this is where you will find out, do they have full authority or limited authority? Okay, so full authority. Full authority, great news, no court confirmation is needed. It is very similar to a normal listing. While yes, you do need to use the probate, listing agreements. That is going to be one of the biggest things you see difference. Title will need a few extra items, but it's very similar to that. And yes, the probate referee appraisal will still be needed. But if somebody has full authority and no court confirmations needed, then it's very similar to a normal listing. But if they have limited authority or really no authority, a court confirmation is needed for the sale of the property. Okay, so when you think of probate listings, a lot of times you're like, oh, I don't want to have to go to court. I don't want to have to do all this stuff. This is when it happens. Full authority, it doesn't happen. This is where it happens where, yes, we have to go to court. So the court confirmation is needed. It's very different from a normal listing. Yes, you do still use the probate listing agreement, those forms and all the addendums and so forth with that. And yes, the appraisal from the probate referee is still required. I'm going to, and give you just a few minutes, I'm going to talk more about what that court confirmation process looks like. But interestingly enough, when you are listing a house in probate, there are certain disclosures that the seller is exempt from having to complete. Some of them are really odd to me, but it is what it is. Okay, so some of the requirements. disclosure exemptions, which the seller is not required to provide. They don't need to provide the real estate transfer disclosure. They don't have to complete the seller's property questionnaire, which I'm often asking, well, why? Well, let's just say son lives in New York. He's never visited mom's house in Murrieta. How's he going to know that the toilet has a leak? Or I don't know, whatever else can go wrong with the house. The roof is leaky, right? If he hasn't lived there, he can't fill it out. He doesn't have that knowledge. So they don't have to complete the natural hazard disclosure statement, the homeowner's guide to earthquake safety, this is the oddest one to me. They don't have to have an operable smoke detector. I don't understand it. I'm just going to say, I'm going to go on record. This is being recorded. Just do it anyways. Make sure that the smoke detector works, but no, it's not an actual requirement. Okay, here's what they still must do. They still have to disclose any material facts known to them. Okay, they have to disclose the hazard zones, make sure that there's properly installed water heaters, disclose any lead-based paints, and they have to do the carbon monoxide detector. So I've never understood it. Why not the smoke detector, but why the carbon monoxide? I don't understand. Again, just do them both. And they have to comply with the sex offender database disclosure and the tax withholding requirements. Okay, so those are a few differences when we're going through a probate sale within a normal sale. Go ahead, Felipe.
So I was just going to add to that because this is where I get a lot of questions in the real estate industry side of things. Just going back to the probate listing agreement. Mm-hmm. So there have been a few changes recently. So there is no actual probate listing agreement. It's actually a regular listing agreement with a probate addendum that's going to get attached to it. So just that way, if you guys are going on car and you're looking for the form, you're not going to find it. Just type in probate, everything will spit out. But it's a regular listing agreement with a probate addendum that gets attached to it. Now, the next big question I get all the time, and it has to do with the natural hazard disclosure report. And the reason I get the question, because if we go back to your first slide, it says the natural NHD doesn't have, or the natural hazard report doesn't have to be provided, but you do have to provide the disclosure hazard zones. What does that mean, Felipe, right? Everybody always asks me that. So basically, the NHD report still requires, or I'm sorry, the disclosure is that we still have to inform, the seller has to inform the buyer if the house resides in one of the 6 known hazard zones. So where would I get that? I say just get the NHD report, because then there you go. You still have the opportunity to get the report. It has the NHD information on there. It satisfies the requirement that the seller provides to the buyer, and you're good to go. But basically that's the difference is, look, you know, they don't have to buy the report, but they are still required to provide if the home resides in one of the 6 known natural hazard zones. So just get the report. The next thing is disclosing material facts, and this is a big one. Again, just because somebody is exempt, the form for disclosing material fact would still be the ESD, the exempt seller disclosure report, disclosure, I'm sorry. So make sure if the seller's family doesn't have information, right? Which we all know that families still, even though the son lives in New York, I'm sure you talked to mom recently or at some point, and you know what I mean? Like, unless they don't, but they should know if the roof caved in and they had to help mom and dad fix the roof, 2 years ago, or hey, so-and-so passed away in the property. Any material fact that they are aware of, they still have to disclose. And the form is the ESD. So just make sure you guys take note of that. And then Marianne Shoup said that I saw a chat. I just missed it. Did anybody catch that? I'm sorry. She just chatted something on there.
I was just saying, when you get that NHD report, you also have the indemnification. So that's what you're paying for, is the coverage.
Right. So just wanted to clarify those 3 things. And I agree with you, Andrea. You need a CO2, but you don't need a smoke detector. It doesn't make sense. Just make sure it's there, right? Take care of your clients, make sure it's there. And I just wanted to clear up those couple items. So sorry about that. Thank you.
No, thank you. I appreciate it. All right, so let's talk a little bit about the court confirmation process itself. So one, the notice of the sale must be published in a newspaper. Number 2, it requires a hearing confirming the sale within 30 days of the sale. The confirmation requirements are spelled out in the probate code, and you have to make sure that it's complied with. Now, many of these things, the probate attorney will be handling, right? You're working in conjunction with them. become friends with them, you know, call them up, introduce yourself. You guys really are working together to make sure that this goes through smoothly, because everybody has the same goal in mind: sell the property and sell it as smoothly as possible. So as much communication back and forth that you can, the better. There is an overbidding process. So I'm curious for, I think it was Kimona Associates, when you did the court confirmation process, did you have to, was there any overbids? Was there bidding going on in court? No, okay. So it's really interesting with the overbidding process. When you go to the court confirmation hearing, the court basically says, okay, I'm calling matter, 1, 2, 3, 4 for the Smith probate. This is for the confirmation. Here's the, it looks like the selling price is $550,000. Do we have any overbids? And it becomes an auction in live court. Again, this is where I geek out legally because I think that's so cool. And so the judge actually becomes an auctioneer. It's like, okay, do I hear $5,000 more and $10,000 more? So we have to comply with that overbidding process. So all overbids, the initial one they have to be in writing and filed with the court. They don't have to have it done in time for it, but it's right afterwards that it has to be filed with the court, all the information for that overbid. And I'm going to talk about how to calculate the overbid as well. Let's see. The special rule regarding the broker's relationship. So let's just say it's your, I don't know, your sister, right? Or it's your who is the executor of this estate. Of course, she's going to want to give you the sale because it's your sister. Unfortunately, there are rules against the relationship that either the agent or the broker can have to the buyer and as well as the executor of the estate. So you just have to make sure you're aware of that when you are listing the property. So this is a copy of the report of sale and the petition for that court confirmation. When you're doing it, this is where we're going to need some information from the agent, how much of the property is going to be sold, what's the description of it, and so forth. This is where we're going to have the appraisal value. This is where we're getting it from the probate referee, because the probate referee value is very important. I'll talk about that in just a minute. And also the terms of the sale, we have to complete that. On the other side of this form is where we talk about the overbid. So this is the formula for calculating the overbid. So it's very interesting, but I'll explain it. So first we take the original bid, and if that original bid amount was $550,000. Okay, we have to take 10% of that, the first $10,000. Okay, well that's $1,000. Then we need 5% of the original bid minus $10,000. Well, you do the math, that comes out to $27,000. So you add all those together, and the minimum overbid must be $578,000. So if the original bid is $550,000, the first overbid must at least exceed it by $28,000. It's so that we don't have someone going into court and be like, yeah, I'll give you $10 more, right? No, let's make it worth everybody's while. So that's how you calculate the first overbid. After that, it's completely up to the judge. Usually they go in, $5,000, $10,000 increments to make sure that, again, it's enough of a jump so that it is worth everybody's time to go through that. So that's how you calculate that overbid amount. So we must accept the highest and best offer. Keep that in mind, highest and best overall. Okay, and we also have to open up the listing to the open market. Make sure you list it on the MLS. Please. I actually had a probate, I guess it's been about 2.5 years ago, but the agent didn't market it on the MLS. He put a sign out and we had a buyer. Well, the probate referee actually called my office like, hey, Andrea, did you know this wasn't listed on the MLS? Like, who doesn't list it on the MLS? So we had to, completely disregard the offer. The agent couldn't serve anymore, everything. We had to list it on the MLS, make sure we open it up to the open market. So there are requirements that we have to comply with when we're dealing with a probate sale. And you have to make sure that the offer that is accepted ultimately is at least 90% of the probate referee's value. So if the probate referee, lists the property and says, well, it's $100,000 value, well, you have to accept a $90,000 at least offer for it. Okay, so it has to be at least 90% of the probate referee appraised value. All right, and in case you were wondering, yes, you do need, let's see. Oh, no, you went too fast, sorry. Yes, you need a certified copy of the order, and yes, you need certified copies of the letters. So the title company will be asking for that when you go to close, certified copies of both. So a few more challenges when selling property in probate is, one, we have little access to funds for repairs or costs. Improvements, they may not be reimbursed by the court, so you have to make sure you're aware of what can and can't be done. Again, please talk with the probate attorney so you guys are on the same page. The personal representative must adhere to court standards for decisions, which they're not decisions that we might make personally. It has to comply with that person's role as the personal representative, as the administrator. Usually there's no help for cleanouts, junk removals, and so forth, because remember, we got son in New York or family all over the place, unfortunately. And also, most importantly, remember, you are talking to a grieving family. This is such a difficult time. It's very real. They've just lost somebody, usually that they're very close to. So it's a very sensitive time for that family. We got to make sure that we help them through the process the best we can. So make sure that we continue to remain flexible. We've got to expect the unexpected. Again, work please closely with the probate attorney, and nothing is final until it's final. We have to have court confirmation of the sale ultimately. If not, the court can reverse that sale, and we do not want that. So resources for your seller. I will say, when we're looking at the resources for your seller, number one, take the listing. One of the best resources that you can offer your seller really is you, right? They're talking to you for a reason. They trust you. They want to work with you. So if you can, take the listing, and then make sure you have a great probate attorney that you work with, that you can talk with and talk about it. I was talking to an agent. I got a phone call back in the fall, I don't know, October, November. And he's like, hey, Andrea, I got your name from someone else. I have this house that I need to list. It needs to go through probate. How does that work? I'm like, you know what? Great. Thank you so much. Introduce me to your seller. Let me start that process, get that probate process started. Then it's the listings coming right back to you, right? When you have a good relationship with the probate attorney and you're having them take on your client and help you out with it, you kind of protect and insulate yourself. Because one thing that I've heard, and that's is, well, I don't want to lose the listing. I don't want somebody else to kind of sweep in and take that listing from me. If you're working with an attorney that you have a relationship with, your listing's basically protected. I mean, gosh, how dumb would somebody have to be to make sure that you don't, have that listing come back to you? So, make sure you're working closely with that a probate attorney. They're also a great resource for you with questions. Make sure you have an amazing title company. You've got to make sure you're pulling title early and often, so so you understand. The last thing we want is to be surprised. How many times has that happened? Marianne, Carl, how many times has that happened when all of a sudden you're getting ready to close and then you're surprised by something? That's when we, look at the preliminary title report and something happens, you're surprised. Tell me about that.
Well, it can happen often, for sure. We're always trying to be proactive with getting information out to our clients, even in our reviews as well, calling attention to anything that's important ahead of time, as well as documents we might need for closing, for signatures of people that are on title, right, or that have rights to that particular property.
Yeah, your title rep can become your best friend with this. So make sure that you pull title early and often. And if you don't have access, that you can't pull it yourself, I know Marianne and Carl can help you out and get you access to a program so you can pull that.
Well, I would even suggest, though, not relying on the online databases that us and so many title companies offer, because they can be inaccurate. So right. A lot of times what we try to do, and we encourage our agents that we work with to do, is to contact us before the listing, and we want to go into the chain of title and pull the last recorded deed, the last vesting deed,
Right.
to make sure that they have that before they go. Because if you just go off of, say, title profile, for example, is even though that's our primary program, disclosure, spoiler alert, it's not always accurate.
Right.
You know, so let us pull the deed through our customer service department, get you the actual how it's currently vested in real time.
Yeah.
And that way you'll avoid mistakes and costly mistakes of that once you take that listing agreement. And then once you secure the listing, by all means, get a listing prelim at that point.
Yeah, it's so important. You know, work in conjunction with your title company, because they will help you avoid those situations. I mean, we've had it where a property is listed. I mean, offer is accepted by somebody who didn't have authority to sell the property. They were trying. I think it was a girlfriend who was trying to do it and almost sold the property. But thankfully, of course, title's like, wait a second, where's your letters? Nope, no letters. Okay, yeah, we're not selling it. Had to cancel it. But they were well underway in that deal. It was awful. Anyway.
Or the other thing that happens too, if I can add one more thing, is the phenomenon known as an uninsured deed, where someone deeded outside of title. You know, there was no purchase, no refinance, and they no longer have a working relationship, so to speak, with that person. We need to validate, because anybody can go to the recorder's office and record anything.
Right.
And slap a cover sheet on that bad boy, and all the clerk is doing is making sure that it's formatted properly, it matches the APN, and you could record the title or the ingredients to your grandmother's favorite stew. I don't know, but they're not there to validate the intent. They're there to validate the format. Right. So if someone deeds to somebody else, and then we need to have an affidavit of uninsured deed, and that person no longer is willing to cooperate, or they can't be found, even though this is somewhat off the probate situation, that's going to be a problem. So when you go on a listing appointment, that also adds to that importance of finding out who currently is on title.
Yep. It's so important. So make sure that you're working with a great title company to help you out with that. You also, have an estate sale company as a resource, because it comes up a lot. Make sure you have a moving company who can help you. That comes up a lot. Make sure you have a cleaning company to help you with that, and as well as a trash removal company and any contractors for repairs. So I'm sure you have many of these, but make sure you have them, because these are great resources that you can offer the clients you're serving. So, and after closing, you've got to help your clients ensure that they avoid this, right? Ensure proper estate planning so they can avoid probate. I've talked all about how to sell property in probate. Remember, everything I've talked about covered only about this much of that whole probate process. So being able to avoid it is such a great service to the clients you serve. I'm often asked, well, how much does probate cost? And Felipe, we were talking about this a little bit earlier about, the values and what value the court uses. They use the gross estate value, so we completely disregard any mortgage. So if you think of a $500,000 estate, right? You think of a modest home, modest personal property, modest retirement accounts, modest bank accounts, pretty easy to get to $500,000. Well, probate fees exceed $26,000. And that's just for the sheer honor and privilege of going through that whole process. Now, I'll tell you, that's a lot of money, and it's really difficult to talk with. I had this situation about a year ago. It was only daughter. Her mom passed away. They lived together, and she was going to stay in the house because that's her home. She had to come up with, I think it was just under $20,000 just to keep her home, just to get through that probate process. It was awful. So unfortunately, that is something that happens, and there was no liquidity in the estate. So she had to come up with some interesting ways to finance that.
And how much does it cost to get a trust?
It really depends and varies. It depends on the situation. So we help people set this up all the time. For a very simple situation, usually for an individual, it's about $2,900. For a couple, about $3,400. And then there's complicating factors from there. So, it depends on the situation, but that's a good starting point as an idea. So a properly drafted, properly funded trust will completely avoid the probate process, and that's really what we want to do. So I'm going to give you a little bit of vocab in a trust. Roles in a trust: trust maker, trustor, grantor. This is the person who makes the trust. That's their job. If I'm setting up my trust, I'm the trust maker, right? It's my job to set it up and create it. Number 2 is the trustee. Their job is to manage the trust and make decisions for the trust. They buy and sell real property, open up bank accounts, write checks, anything that really needs a signature. That's the job of the trustee. And then the third job is the job of the beneficiary. Their job is to enjoy the benefit of the trust. They get to live in the house and enjoy the money in the bank account. So during my entire lifetime, I'm my own beneficiary. Only after I pass do my kids become the beneficiary. Only if I become incapacitated or I pass away does someone else step in for me as trustee. But that trustee, that's the person who has the power to sell the house. So we got to make sure that the house gets funded. We talked about that a little bit earlier, what happens when it doesn't, but there must be a trust transfer deed. It must show that it went from Dan Smith and Jane Smith, husband and wife, to Dan Smith and Jane Smith, trustees of the Smith Family Trust. I have a request to go back. Let me go back really quick. Taking notes.
I have a question.
Yeah, go ahead, Rebecca.
So if we have a trust and if my house is in a trust, I'm the trustee, but I give my son power of attorney, but I'm still capable of signing everything. I still have to sign all my stuff, correct?
You still have to sign all your stuff, and depends on how the power of attorney was drafted and how the trust was drafted. Many times they have nothing to do with the other. Sometimes they do. You have to know how they were drafted. Does the power of attorney allow you to do stuff with the trust? Does it not? So it really comes down to how the trust was created to be able to answer whether that power of attorney will affect your trust at all, meaning affect your house and your assets.
So when an agent is taking a listing, what should they be asking their sellers to get copies of so that when they take a listing, they have the correct person signing our listing agreements and disclosures?
Yep. You're going to first pull title. Who's on title? If it's Jane Smith, are you talking to Jane Smith? If you are, that's the end of the story, right? But maybe it's somebody else. Maybe it's Jane Smith as trustee of Bob Smith's trust. You're going to want to know, okay, Jane Smith, are you really the trustee? You got to show me, because title is going to ask for that. Maybe it's, if Jane Smith's the owner, but you're talking to Bob Smith and he's like, oh, I have power of attorney. So it's really case specific. That's why it's important. Pull title early, pull it often, make sure you know who's on title. That's going to drive who you need to talk to. And if it's not the person on title, well, then you have that conversation. Well, okay, Bob Smith, why do you think you can act for Jane Smith? Then if they say, oh, I have power of attorney, well, then I need to see it. Not all powers of attorney are created equal. So I will say, I actually had this situation earlier this year. Unfortunately, somebody did, do it yourself power of attorney online. They thought it would be sufficient. They went to sell the house. They can't sell it. Most online powers of attorney do not allow you to sell your house or anybody's house. So unfortunately, they had a power of attorney, and for the form that it was, I mean, it was notarized, so I guess it was completed fine, but it didn't allow the person to actually sell the house. We're having to do a probate now because that power of attorney wasn't done right. So it's really make sure title looks at it so that they know, okay, hey, this is something, they're either going to allow it or not. Carl, go ahead.
Yeah, in addition to that, thank you, Andrea. Power of attorney is always a red flag for title, because they want to know, we're going to want to know why that person is not acting in their own capacity and for what reason. Because a lot of times it'll speak to mental, incapacitation or some sort of physical incapacitation, and we're going to want to know that. And if it is something where they're incapacitated, we're going to need doctor's notes in addition to that, and see at the time when they executed that power of attorney, did they have their mental faculties to knowingly and willingly of their own volition execute that document. So, because one thing, a sad reality in our world is that, family will screw under family probably quicker than strangers. And so that red flag is always created when a power of attorney is introduced into the transaction.
Yep.
So
All right.
does
I have a
that-
question. I have a question. If you have a trust, do you need a power of attorney or can you just have a trust?
So I'll answer that like this. Yes, you do. They're going to be, well, why? So powers of attorney handle different transactions than a trust. Okay. Let me give you 3 examples. 1, car insurance. Car insurance has nothing to do with your trust. You need a power of attorney for that. Filing taxes has nothing to do with your trust. You need a power of attorney for that. Retirement accounts can't be an asset of the trust. You need a power of attorney for that. So there's different transactions. They're just different tools. You need them both. It's not one or the other or which one's better. It's like saying, well, is a hammer better than a screwdriver? I don't know. What job do you need? Right? So they're different tools with different purposes.
Okay.
Okay. So I'm going to go back to funding your trust. And Rebecca, did you have another question?
Going back to what Carl had mentioned about the power of attorney and proving that the person is incapacitated, we see a lot of elderly people that have dementia, or they'll say, oh, well, my dad or mom has dementia or Alzheimer's. When that paperwork goes to title, we're getting the paperwork from the doctor. The doctor's the one determining whether or not that parent can use the power of attorney. Is that how that works? Like, I mean, what if I just don't want my mom to do it and I'm going to be power of attorney because I'm telling you she cuckoo for Cocoa Puffs?
So here's the thing. So a power of attorney gives power to someone else. Okay. I can give power to someone else, but that doesn't mean anyone's taken my power away from me. So just because someone else has power doesn't mean I don't have power. The only way power can be taken from me is if a court takes it away from me in a conservatorship. Okay, so we're not able to say, sorry, your daughter says you're cuckoo for Cocoa Puffs. That doesn't matter. She will still have the power and the ability to transact. That's where a power of attorney becomes woefully insufficient. That's where a trust comes in, because when a trust is involved, a properly drafted trust will say, if this person no longer has the ability to manage their affairs and the doctor says so, they're removed as trustee and the successor trustee now has that power. So
with the properly constructed trust by Shoup Legal.
Yeah.
Yeah.
Well, some trusts are, it's like powers of attorney. Some are done great and others not so much. So that's the same thing with trust. Some of them are great and they have all these great things and protections in there. Some of them, I read a 5-page trust the other day and I'm just like, oh my goodness. Now, maybe those are the 5 pages that the person who created it cared about because it said their family and who gets everything and who's the trustee. But that's not the other pages that the title company needs to see, the bank needs to see, everything else with all the powers and all that explanation, right? So I stress a properly drafted trust should avoid that and actually provides more protection for the person who becomes incapacitated. Because if not, they can go out, they could have their house basically defrauded out from under them because if somebody has a power of attorney. Anyways, okay, we've kind of got off on a tangent. I'm sorry. I know we're a little over an hour. Felipe, am I still okay on time? I can wrap it up?
I mean, let's get prepared to wrap up as much as we can, but I mean, I appreciate you taking your time. So go ahead.
Okay, perfect. So the next thing, so we must have this trust transfer deed showing that there was a transfer from the original owners to them as trustees of this trust. It must be recorded. That's the only way they're actually on title. I don't care if the schedule of assets on the trust lists the house there. They are not on title if this did not occur. Okay. Mm-hmm. All right. So next, I see this all the time. I see DIY planning, right? People want to do it themselves, save themselves a little bit of money. Oh my goodness, I want to pull my hair out because these online programs, Susie Orman, LegalZoom, Rocket Lawyer, all of them, unfortunately, they give us a false sense of security. They give us an aura of protection and we think it's done right. But like I've been talking about, powers of attorney, just because you have one doesn't mean that it was done well. Just because you have a trust does not mean it's done well. Oh my goodness. Sometimes I wish I had no documents rather than really bad ones. And many times we just don't know how bad it is until it's too late, and there's nothing we can do about it. So really, friends, don't let friends do DIY estate planning. You've got to stay away from it and help your clients. So how do you talk to your clients about this? Well, at closing, you talk to them and say, hey, how are you taking title, right? That's a common question that gets asked. And they usually come and ask you, title's asking me how I take title. What do I do? Well, if they're not taking it in the name of a trust, that's a perfect opportunity to say, hey, let me tell you a little bit about that. That's not a good idea. Don't take it in an individual name. This is one of the biggest asset that you have. You've got to protect it. Go talk to my friends at Shoup Legal, right? When you're taking a listing, you're going to be able to see, oh my goodness, this isn't in the name of your trust. All right, you were selling this, but when you're buying your new house, you've got to get a trust set in place. You've got to talk to my friends at Shoup Legal, because we need to make sure that you're protected, your family's protected. And then after closing, make sure you follow up with your clients. It's amazing to me how little follow-up many people really have. Once the transaction's done, that's it. Call them, 2-3 months later. Ask them, hey, how are things going? Did you ever remodel the kitchen that you had said you were going to do when we walked through this? Whatever it is. And then also tell them, what, I noticed you didn't have things in a trust. Let me tell you, there's this probate thing that you don't want any part of. You've got to talk to somebody about doing that. And go talk to my friends at Shoup Legal. Let them help you get something taken care of. So what we want to offer you is an individual probate training and strategy session. You're going to have questions. I know you do. And I'm trying to be respectful of time, so I'm going to go through it. While I'm available for questions, I know we're running out of time. So what we want to offer you is an individual probate training and strategy session, so we can sit down and talk with you. We'll also make sure that you understand, get your questions answered and understand how to talk to your clients about it. At the end of our time together, we will have personalized training to discuss your concerns and these concerns with your clients, a plan to protect your family, and a plan to protect your business. So we want to make sure that we have that available to you. How this works is it's a 45 meeting, either here in our office or via Zoom. And we're during that time, we're going to train you on how to discuss probate avoidance topics with your clients, to talk to them about it. We're going to discuss your concerns, your goals. We're going to develop a strategy to protect your family and build your business, because when we're more knowledgeable and able to better serve your clients, oh my goodness, that allows you to build your business as well as we're going to answer whatever questions you have regarding your unique situation. So the total value of this is $450. But Felipe, being amazing as he is, he has actually arranged to provide this for you.
Correction, for Century 21 preferred agents.
Yes, Century 21. Yes.
Not family and friends. Hold on. And the good news is we went a little bit over on time, so everybody started getting off the call, so they're missing out. They're missing out.
Let them know that. So no, but for Century 21 preferred agents, it's provided to you for no cost. He does understand the importance of it, wants to build you as agents to better serve your clients, to better understand it, and to make sure that you and your family is protected. So the strategy session for Century 21 preferred is absolutely no cost to you. So thank you to Felipe for caring about your team and making sure that they are protected and they have this training.
Thank you.
How to schedule is in the chat, and you can do it just to me so that everyone doesn't have your personal information, but you can find my name, Andrea Shoup, put your phone number and your email. That's how you will be able to schedule that strategy session with us. What's the catch? There is no catch. This is something that we're going to absolutely provide to you, give you this training. But here's the thing, we only have 25 spots available. So know, our team is exceptionally busy, and that's the only thing that we only have 25 spots available. So
I can only afford 25 spots, all right?
but how to schedule, make sure you put your, not just your name, but please, I need phone number and email address, because I need to be able to contact you into the chat. So we only have 25, let's see, 23, no, 19 spots available. So, you know, make sure you put that information in there to get your individual probate training and strategy session. And one other thing that I'm going to offer to you is we will offer personalized client presentation. Okay, this is a personalized presentation to your clients, prospective clients, and their friends, a great marketing opportunity for you. And we're gonna provide that to you. Message me client presentation with your email address, and I will say we only have 4 of these available presentations available in August. So if you want that, the first 4 people to tell me that they want their client presentation, make sure you put that information into the chat. So that's going to be available to you. So that is what I have for you today. I am happy to answer your questions, but we're going to do that at the individualized strategy session. Felipe, thank you so much for the opportunity. I hope this was valuable. Was this valuable? Does this
extremely valuable. Thank you so much. And thank you, on the contrary. I mean, you did an amazing job. You know, this is a huge opportunity, and I hope that our agents, you know, unfortunately, most of them are going to be late to this party, and they're not going to be able to get, you know, the 45 minutes with an attorney to go over probate so you can fully understand. And Andrea, did you say by the end of the 45 minutes, we are now certified attorneys in the state of California? Right? it's like passing the bar, right? So, but no, you did an amazing job, and honestly, tell David that we'll take you anytime over David. How about that? No, he's gonna be so upset at me.
He told me yesterday, he's like, yeah, he said that, you know, something about like me presenting and versus him. I'm like, oh my goodness, you guys are funny.
So, you know, the Shoup legal team, they're our personal, well, my personal legal team. They handled my trust, my estate, the company. So we wanted to make sure to provide you guys some useful information regarding probates. The one big key thing, the biggest question we get every single time, and if you text me today and ask me about a trust, I'm going to be upset that you weren't on this call, but the number one question we get all the time is, hey, I have this listing coming up and it's in a trust, who signs it? Yes. If I hear that question this week, I swear, Rebecca, I'm going to sick Rebecca on you guys, because you should be here. You should be listening to this stuff. Fortunately for everybody, it is recorded, and we are going to share it with everybody.
If an agent comes to me and says again, who signs the trust, I'm going to say, I can't give you that answer. Go watch the video.
That's it.
There you go, Rebecca. I like that.
Or talk to Marianne and Carl, because you know what? You should be watching this, but it will be recorded. Andrea, thank you so much again. I had one quick question.
Please.
So who stipulates commission?
The court does. If it goes through court confirmation, the court does. They have their requirements. Yep, so we have to comply with that as well.
Yeah, and I'm sure that's the question on everybody's mind. So we're going to go ahead and allow people to, you know, obviously we're way past our time. I'm not going to turn anything off. If anybody's on the call, if you want to ask a question, now's a great time to do so. Marianne and Carl, thank you again so much. Great advice, great information. A great resource for tools to reach out to your database. I know Marianne and Carl were chatting about that. Feel free to reach out to them as well, you guys. But if anybody has any questions for Andrea, now's a great time. We already answered commission. I'm going to throw one more out there while people are trying to write in.
I have a question, Felipe.
Go for it. Is that Donna?
I have a question. Yes, it's Donna. Hi, Andrea.
Hello.
I recently lost my dad about a year ago, and
so
they owned a condo. So thank you. So we did a trust for my mom. And is the document that you were talking about a trust transfer deed? Is that the document that took his name off and just put her name?
There's not enough information that I have. I strongly suggest schedule a strategy session with us. I need to see it to understand what you're talking about.
Okay.
I don't have enough information to be able to answer that effectively right now. But
Okay,
if you bring that to our strategy session, I'll be able to tell you.
Okay, I sure will. Thank you.
Absolutely. Thank you.
And it's a free session for you guys. So yeah, take advantage of that. Great questions. One question I had, unless somebody else jumps on real quick, is what kind of deed is given after a probate sale?
Yeah, so actually it's, we can do an executor's deed, but usually it's actually a court order. So in the petition for final distribution that we file, we prepare a court order, and that court order is actually the judge saying that this property, we have the full legal description, commonly known as with the address and the APN number, now is distributed to, and then the person that that's distributed to, we record that order. So that is essentially the deed, if for lack of better words, because it really isn't a deed. We can't do a deed because there's not a, there's no one signing that deed if it's distributing. That's distributing through the probate. That said, when we're doing a sale through probate, the executor is the one who's signing the document.
The executor signs. It does. One last question from me. What happens when, because again, my agents are shy, I guess, all of a sudden. What happens when probate is taking place, a court is taking place, and there's no agent assigned, no real estate agent assigned?
Go knock on that door. You know, I mean, really, so then if I'm working with a client, there's no way we're selling a piece of property without an agent. It's just never going to happen. Nobody will ever be able to convince me otherwise. Okay. So, I mean, we need an agent. So if you're aware of one, hello, prospective client for you. So, yeah, that's what you got to do. And an agent is not appointed or assigned by the court at all. Okay. It's the executor who makes that decision of who it's the realtor will be, who the agent will be.
Sounds like a resource for business. So again, everybody, thank you so much for being on the call. Does anyone have any questions? Last chance, last opportunity. Andrea is a great partner to have in your pocket. Absolutely. The Shoup legal team's been doing a fantastic job. They represent us as a company and my personal stuff. So hi, Don, do you have a question? No? Okay. All right, guys. So if nobody has any questions, I want to say thank you one last time. Andrea, thank you again for your time. And I hope everybody takes full opportunity of this. If you follow an ambulance to a property, does that make an ambulance case there? Yes, it does. It does. But if we bring donuts to Shoup Legal and stuff, I don't think that's called ambulance chasing.
Not at all.
Ellen, did you ask a question? I'm sorry, I just saw a chat. Ellen? Oh.
I saw when there was a question if can a realtor be the trustee as well as a beneficiary as well as a selling agent?
Oh.
Yes, it can. I would want a little bit more information. If it's like the sole beneficiary, you know, then there's really no issue with it. Go ahead. But that's trustee. That's not agent through probate. But I would want more information. If there's other beneficiaries involved, then usually not. So there's a thing that avoids self-dealing. Okay, so employing yourself is self-dealing. However, you know, great you are and pure your intentions. So you have to see also if the trust language allows it. So a properly drafted one, I usually include a blurb in there that says, yes, a beneficiary or who is also the trustee can engage in self-dealing. It's fine, but you have to have that actually spelled out in the trust to allow it. So yes, you can. I would want to know more information to make sure it's a good idea too, and then also make sure that the trust allows it. So hopefully that answered your question.
Did. So I think we're good. I think no one has any questions right now. Everybody take the opportunity, sign up right away. There's only 25 spots. I don't know how many people have already registered. So we're good. Have a great rest of the week, you guys. Stay safe out there. We'll see you soon. Thank you so much, Marianne, Andrea. And do you need to keep track of who responded here? Or
yeah, if you could give me just a second, I'm going to turn off my video. If you could just leave it live for me just for a few minutes, that would be great.
Okay, cool.
Thanks so much.
What's up, Daniel?
Thank you.
What's up, man? Is that your game room? What, you look like are you playing video games in there? Look at that. What's up, Becky? David. Hey, you guys, take advantage. Sign up for that. Send her an email. 45 minutes. on the house. Rebecca, it's coming out of your, David, we'll take it out of your $1 million listing you got coming up. There for life, that's Denise, Linda, Karen. What's up, Linda? Linda Rubio, Robin. So guys, please, please, please definitely send her the invite, or I'm sorry, send her an email, get yourself situated. 45 minutes, that's a long time to go over any questions and just truly understand the probate process. Don't be that agent that calls me later on and asks me, who do I fill out my listing contract if it's in a trust? Nora, no, I'm just kidding, Nora. Nora, we miss you. What's going on? Are you in the desert? What's up?
Yeah, miss you too. Hey, I'm having a new listing coming up. Are we talking about that or no?
Yes, go ahead. I mean, a lot of people have already, gotten off the call, but please share. Absolutely.
Well, I'm gonna send an email on Facebook, but
okay.
I have a listing coming up, and it's gonna be a fixer-upper. It's gonna be on the Vail Ranch area, by Red Hawk.
Yeah.
And if somebody is looking in that area, it's a 1559 square feet home, and it's gonna be under asking price. Like the comps are from 419 to 459, 469. We're gonna be selling like around 380, 390.
Wow.
Yeah. So the only thing catches is it has a lease, solo lease.
Okay.
But with negotiations, we can get that going. So if anybody is looking in that area, please let me know. And
yeah, absolutely, and definitely put it on our page so we can pass it out too.
Yeah, you know what? I'm gonna put it on the page, on the private page after this, because it's gonna be probably live on Monday. And Felipe, I'm gonna call you in a few minutes as well.
Okay, cool. Sounds good.
Right. Bye.
Bye.
Nice.
Oh, Linda just said, will it go FHA? Nora, are you there?
Yeah. Well, you know what? It will go. It will go FHA. The only thing I just ordered the termite, and we might have a problem with the patio cover.
Okay.
That's the only issue. Other than that, it's pretty much cosmetic. They just, drawers not closing properly, things like that.
Wow.
But other than that, it has a brand new AC unit. So, usually that's one of the problems, the newer stove, etc. But yeah, it could go, but just that.
And why so low? Is it distressed? Is it?
Well, they want to sell fast. Plus, they know about the solo lease might be a problem. It had to be assumed that, or like I said, with a good offer, they can pay it off. So they just want to move on.
Well, there's a lot of interest. So Robin, there's already a lot of interest. So yeah, definitely let's put out the information on that. That should go really fast.
Okay.
Should go really fast.
I wanted to let you guys know because, like I said, it's going to go live on Monday.
Okay, cool. Yeah, well, we'll definitely get an opportunity to take a look at what you send out. So look forward to that, and call me later.
Okay, we'll do.
Okay.
Bye.
All right, guys. So Andrea's done. I want to stay here all day and just talk, but I can't. Got to get back to work. Rebecca, who do you think is going to be the first person to ask us about a trust and how to fill out a listing contract? We should put a side bet.
I know, we should have a side bet on that.
David, it better not be you, man. It better not be you. I see you right there.
You know what? We should have taken a list of who attended today's meeting. And
I have
the
it.
person, okay, good. Because if somebody that attended the meeting asks about a trust, that means they weren't really present to what we were talking about today.
I already know it.
And then they have to buy us lunch.
Chris Finocchio is not on the call. I want to put my money on Finocchio.
Okay, yes, but
no, you know, Brian. You know, you better
Chris
not.
I'm holding Chris Holden
there
responsible for him. Oh,
Chris, if I get that, oh man, I'm gonna go over there so I can go talk to him. All right, you guys. Brian, it better not be you. I know you were taking notes. All right, all right. Hey, sign up, you guys. 45-minute free consult. Talk to them. Get your questions answered. Too bad you can't get certified by doing so, but it's almost like taking a probate class. Great opportunity. So I hope you guys appreciate that. Get out there. Let's get some listings. We'll see you guys soon. Okay. Talk to you guys later. Take care, everybody. Bye-bye. Adios.